all of these sections put all of the risk onto the user and none of it seemingly on Coinme.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, experienced startup general counsel and author Paul Swegle tears down the Coinme terms of service. Coinme is a company that allows consumers to buy Bitcoin from a kiosk in a grocery store. You can imagine how new many relevant questions are. Paul balances a drafter's need to be safe with the hope to not turn off regulators or courts from Bitcoin's wild frontiers. So let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. The purpose in this show is exactly what it sounds like. We take contracts, we beat them up, we say mean things, we tell them to improve, and we do it with smart friends like Paul Swegle here. Paul, how are you today?
I'm doing great, Mike. How are you doing today?
I'm okay. I've been sick for like the last week, so I apologize to the audience if I sound like a Muppet today, but I have been sucking on cough drops like nonstop for the last 2 days because the signal cannot be stopped. We are going to talk about contracts, and the document we're talking about today is this one. Let me share it with you guys. This is the Coinme Terms of Service. Paul, before we dig into this, tell me what this document is. What is Coinme? What is this document for their terms of service?
So Coinme is a company that allows consumers to buy Bitcoin through kiosks at, I think, virtually every grocery store and probably other public places, malls. I believe they're doing this in some partnership with Coinstar. So I think these are all at Coinstar terminals, if I'm not mistaken. And, you put in cash and you follow their process and you get Bitcoin. And so these are their terms of service that apply to all transactions and all Coinme accounts.
So presumably the way a user is experiencing this is they're standing at a kiosk at a Walmart, their kid's screaming in the cart. And in order for them to buy this, they got to push a couple buttons to say, okay, I'm cool with this. I assume this is being emailed to them separately, but their primary experience with this is push the button, get out of the store, right?
That's sort of it. You interact with the kiosk, you get a voucher, and then and before you put money in, you look at their terms of service and looking at some videos on YouTube, they're very compressed and you're scrolling through, just 3 or 4 lines of text is what it looked like. But then you do have to take that voucher and go to coinme.com/redeem, I think. And you then are likely presented again with these terms of service. And then you set up a wallet and your coins hopefully appear in your newly established account wallet.
We were always worried about the law companies showing up in Walmart. Turns out it was Bitcoin that was taking us out of the grocery store experience. Well, Paul, before we dig into the particulars of the document, tell us about you. What's your background with this kind of technology? What's interesting you in this document?
Well, so I did happen to notice that Coinme was looking for a general counsel, and so I was a little bit interested in the company. And I went online and did some research. They raised a lot of money recently, so that was a positive. And I was a little bit interested in Bitcoin and being able to buy Bitcoin with small amounts of cash, so that was interesting. I did notice on several websites like Trustpilot, Reddit, BBB, that there were a number of issues with customers having challenges getting customer service and getting access to their tokens and getting access to refunds. And so I was, slightly, not as interested after I saw that. But I have been general counsel to a dozen tech companies. I'm currently general counsel to 3 tech companies, 2 in the virtual health space, 1 in what we call MarTech, marketing technology. And I have also been involved in a lot of fintech and financial services. So I was general counsel of a company called ShareBuilder for 12 years, which was the fastest growing online brokerage. Then I also worked at ING Direct when they bought ShareBuilder. And then I also helped set up another fintech company called ZenBank. So I'm familiar with terms and conditions, not only for tech companies, but for fintech, and Coinme is a fintech. And so I thought it was kind of interesting. I also have written a book that's pretty popular called Contract Drafting and Negotiation for Entrepreneurs and Business Professionals. And so I do like contracts a lot. And another book that I've written, and both of these are used in law schools and MBA schools across the country, Startup Law and Fundraising, a much bigger book. But the Contract Drafting book is about 150 pages, and I think a pretty good read for anyone who's working regularly in contracts, whether they're a lawyer or a business person.
That's right.
But yeah, I was invited to participate in Contract Teardown, and the Coinme agreement was one I looked at. And as we've discussed behind the scenes, I did notice there were a number of provisions that are worth discussing.
Perfect. Well, I appreciate that. And yes, you always have to product place the book, you see, lawyerforward.com, check it out. Yeah, you always got to get the book in there. Okay, so what we're going to do, Paul, is go through point by point some of the sections. I mean, the sense that I got from you was, in general, A, this is the wild westy space. I mean, Bitcoin just is, and B, this is pretty one-sided because there's just a lot to protect in this kind of space. And so we're going to go on that theme through specific points. So what I'm going to do is take you first to 4.3. There's this point about access, and I assume this is talking about accessing the token. So I buy the thing, I'm at the store, I put in my $1,000, and it says, hey, you've got Bitcoin somewhere, but you got to go get it. Tell me about this section. What do you like and not like about this access section?
Well, and again, overall, these terms and conditions or terms of service, they're very robust. Lawyers working in the fintech space might be well advised to take a look at this contract just to get a sense of the overall level of protection and the different areas that are addressed. But by and large, all of these sections put all of the risk onto the user and none of it seemingly on Coinme. And so in this section, this has to do with access to your account, access to your wallet, access to your tokens that you've paid for. And essentially, the upshot of this provision is if for any reason you do not have access, if access is limited or the platform's inoperable, you accept and assume all risk associated with your inability to access your account. And we'll talk about this later. I don't know what regulators would think of a provision like this. I don't know what a judge would think of a provision like this. I understand the sentiment and why they wrote it in such a sort of a severe way. Right. But there's a possibility, one, of attracting regulator attention if your terms and conditions are just very sort of almost unconscionable. And then secondly, a court might rewrite them. Right. Courts do have some latitude to rewrite unconscionable provisions. If the platform is down, it's unavailable, and it's because someone at Coinme tripped over a plug and pulled the machine down, and it's just, and it fries and the whole thing is, flat on its back. Is it really, in the end, the user's full risk, Sure. And just loss?
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Was that foreseeable? Was that something that, was that a trade-off that they made? And as a variation on the theme, I mean, if you go down to 7, they underline it. I mean, there's bold text down here in the assumption of risk and release of claim section where it basically says, it's on you, bro. Like, what do you think about this this section 7 and this assumption of risk and release of claim section?
Well, it's common to see this type of language in other contexts like SaaS and just everywhere. You see it, but it's particularly concerning with financial services, with fintech. If this was a broker-dealer or if this was a bank, I don't think they would be writing
Right.
half of this, because regulators just probably wouldn't stand for it. When I was, at regulated entities, we just always had in mind this regulatory context that we may want to write it really one-sided, but at the risk of it being rewritten or at the risk of it attracting regulatory ire, maybe we should balance this, or at least use words like good faith or best commercial efforts. There's some of that, but maybe in one or two places, but certainly not here, where it just says you hereby irrevocably waive, release, and discharge any and all claims, whether known or unknown to you, against Coinme, any third-party operator, blah, 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 for essentially any risk set forth herein. Right. Those are the words. Any of the risks set forth herein. And it's all the risks. That your your coins are stolen, that the system goes down, that your account is closed, that they can't fix a mistake. It's just all on you. I don't think I'm misreading it. And it's a little, in the law, I think we would apply the word draconian.
Yeah. Side note, and you may not know this, does insurance exist to protect against the risks that are associated with this kind of thing? Because it feels like, when comparing to other, financial goods, right? When people are buying financial services and in the banking system, I mean, you can get insurance for these kinds of risks, but I'm sure it will exist soon if it doesn't exist yet. But I don't think it exists yet.
No, as we all know, federally, bank accounts are essentially federally insured, and brokerage accounts are insured through an insurance fund called SIPC, Securities Insurance, some protection right. Corporation, I think. And so in this little bit more Wild West, Coinme is regulated, as a money service business, an MSB. And there is currently, to my knowledge, no state or federal insurance scheme for these funds. Now, interestingly, we don't know whether or not Coinme has insurance, and their insurance that they would have perhaps would be some sort of professional liability insurance. But we don't know about that, and they're certainly protecting themselves, or to the best of their ability, that they wouldn't have to make claims against any available insurance. So these are uninsured accounts, and the four corners of the document suggest strongly that the users are at 100% risk, and that risk may or may not ever come to pass. But it is Sure. it is the way it's drafted. On all risk is on the users.
Yeah, and to your point about having read about service issues, and let's jump down to 11.5, where it talks about error correction attempts. Coinme provides no guarantee or warranty that any such attempt will be successful, and will have no responsibility or liability for the error. What do you think of that section?
It's kind of more of the same, and it kind of puts me back, in roles where I've had where maybe it wasn't an error of my company technically, but something happened with a software rollout, and company went down during market hours and caused hundreds of thousands of dollars worth of losses potentially. And just being a regulated entity, knowing that the regulators would be watching how we handled this, we pulled together a task force that I headed up, and I was, given more than $250,000 to work with, to reach out to 9,000 customers and talk to them, email with them one by one. I had a task force of like 25 customer care agents. We addressed every individual customer. How do you think this impacted you? What do you think the loss is? How can we fix it? And with language like this, maybe they're a little bit too comfortable that they don't have to go to those steps, those lengths if there's an issue. But maybe they do. But if you look online, there's sort of a pattern that issues are not addressed as quickly as customers would like them to be. And I don't know if they're taking comfort from these terms and conditions, or, as I suspect, they're just growing. They have staffing challenges. They have system challenges. It's probably not as mature of a system or an organization as they would like to be, and they're doing the best they can. But needless to say, there's complaints that are showing up online about support and fixing mistakes, fixing errors. And a lot of the errors may be by the customers inputting bad information, losing their little voucher, having problems in their background that show up under the Anti-Money Laundering Act, right? So they're not getting through the Know Your Customer, process, and it may or may not be Coinme's fault, but there's a perception online that the remedies aren't fast enough and sufficient enough, it seems, in some cases.
Well, take me about down to 17 to the disclaimers of warranties. Again, all caps, no warranties. It's as is. Is this common in this kind of business, in a financial services business, to make a disclaimer of warranties that's that broad?
No, I would say probably not, because normally you would have some language where, it's clear what they will do. And maybe they might not state we rep and warrant that your account will be secure. We rep and warrant that your transactions will be effected faithfully as requested. But there's certainly an implied regulatory obligation to do those things. And then you might see disclaimers of warranties that say, except as otherwise provided in here, or except as to the warranties above in section blah, blah, blah. Right. We disclaim all other warranties. This is just a blanket disclaimer of all representations of warranties of any kind that the platform will perform, that transactions will be, processed as you would expect them to be. Essentially, it is as is, which means with all faults and as available. So there's absolutely no representation or warranty of any kind, which with a financial service, I think that probably is more overreaching. I think if I didn't look at PayPal, but I'm not sure that, I don't know that they would make as strong of a disclaimer of reps and warranties, but I could be mistaken. But a bank or a broker dealer, I don't think would.
Yeah, and I'm so curious, what would PayPal have said in 1997 or whatever year they started, when they were dealing with all the operational crises that Coinme is probably dealing with, versus their phase now? And will regulators give them the benefit of the doubt and say, well, you guys are new, it's fine? And the answer is probably not. Jumping down to 18, indemnification. Again, the one-sidedness, but what are you seeing in this section?
Well, this clause has some language I've been seeing in other agreements lately. And it essentially requires the user to defend, indemnify, and hold harmless the company against the user's use of the system or use of the software. It was previously more common that it would say misuse of the system, misuse of the software, changing of the software, using the software or the system in ways that were not intended. But here, you have to indemnify and defend and hold harmless Coinme from any claims relating to your simply using the system as it's designed. That strikes me as a bit of an overreach. Whenever I see that in contracts that I'm negotiating, I either strike it out or I say, we'll indemnify each other for our breaches of the reps and warranties and obligations we each have under this agreement. And then it's more even-handed, right? But there's no indemnification by them of users for anything. And the one that's usually at least made is claims regarding intellectual property, because even end users of a platform that infringes someone else's patent can theoretically be sued, right, under patent infringement. But it's one-way indemnification simply for using the platform. And then it goes even further. It says that they, Coinme, and it also, the kiosks are run by a third party. I think that might be Coinstar. Coinme gets to control the defense of any such claim. Mm-hmm. So they're in charge of it. So even though you're paying for it as a user, theoretically, you're not in charge of how well they defend the claim, and they also can settle it in their own discretion. So pretty one-sided all across the board, merely for use of the system. Bit of an overreach, it strikes me as.
Right. I like the word theoretically applied there. Finally, the last section we'll talk about before getting the big picture is 19, limitation of liability. What about that one?
Well, in some, their liability is limited to $100 to the user. And it's and that was paragraph 19, you said? Yes. Mm-hmm. So it's to the fullest extent of the law, so they realize this might not fly, maybe. In no event will the aggregate liability of Coinme or any of its service providers, i.e. the kiosk provider, whether in contract, warranty, tort, including negligence, whether active, passive, or imputed, blah, 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 will the liability exceed $100. So just for whatever. If you put in $10,000 and the system crashes and somehow your coins are stolen or what have you because of some negligence, they will owe you $100 by contract. Now, whether that would fly, whether they would actually do that, sometimes, companies write in very stern, draconian provisions and they don't really maybe intend to enforce them. But I always tell people on the other side of a contract that, assume the other party will enforce everything. Assume the worst.
Well, to that point,
put it in.
I want to think big picture with this because it's an interesting, yes, it's a document. Yes, there are best practices for terms of services, all true. But we're dealing with a pretty weird context. The Bitcoin context is very, like you and I talked about, it's very Wild Westy. Take me to the mind of the drafting attorney in this scenario. Given that it is so Wild Westy, I feel inclined to say, well, I'm just going to be overly protective. I'm going to be kind of crazy in here. I'm going to limit liability to $100 because why the heck not? What would be the other argument? Why would I say, let me create a document that's not so one-sided, that gives more leeway to the person who's probably not going to read this until there's trouble? Why draft differently than this?
Well, so my guess is that an outside lawyer wrote this, not someone in the company, and that's supported by the fact that they're currently looking for a general counsel, which to me suggests they don't have any lawyers in-house, and so they had outside counsel write this. Outside counsel, their job is to protect, and when they don't, they can be on the hook for malpractice liability, right? So outside lawyers tend to be more conservative. An in-house lawyer might sit down with the CEO and go line by line over this and say, do you care if I put in good faith right here that we'll not only commercially reasonable, but in good faith and that we'll try and fix these mistakes? Do you care if, we don't cap liability at $100, but, maybe we go up to $1,000 for a proven loss, right? Some kind of guarantees, like, we've got you, and then make sure that we have insurance to cover that and talk with my insurance carrier to make sure we can make that promise. And that really isn't maybe just because a customer, 1 out of 1,000 customers sees it and says, I'm not getting Bitcoin here. These terms and conditions are too harsh. I don't know that many people read them and know how one-sided this is. But I think regulators, if I have to deal with regulators, State's Attorney General, the Federal Trade Commission would also potentially regulate them. I just don't want to throw a document over to a regulator that I know is probably not going to be well received. And if something is challenged in court, as I mentioned earlier, if something's really unconscionable, a court can throw it out and I think can rewrite it. It's kind of state by state law. And so if I strike a balance that's a little more even keel, maybe I feel a little more inoculated from potential, court action voiding a provision and potentially rewriting it in a far more consumer-friendly way. I understand why they wrote it this way. It's probably working just fine for them, but those are the concerns that I would have about it, is that a third party like a court or a state or federal regulator takes exception to it some way or another, brings an investigation that they might not have brought.
Right. And to your point, I mean, when they've got somebody who's internal, who's thinking about the big picture and the ecosystem that they're trying to create really with the Web 3.0 stuff, I mean, it is the Wild West. They're creating this frontier as they go. And so it might be rewritten later to be a little more community driven because this area really does have this sort of sense of community. It's not this detached banking environment. So it'll be interesting to see where that goes. Paul, I appreciate you walking through this. We will have this document available over at lawinsider.com/resources. For people who want to get in touch with you and learn more about what you're doing, what your work is, what's the best way to reach out to you?
Well, I can be found on LinkedIn. Again, it's Paul Swegle, Swegle. I can be emailed at pswegle@gmail.com. And my 2 books are obviously available 24/7 on Amazon.
That is the modern economy. It's funny because 10 years ago, we'd have had this conversation about how weird Amazon was, and now we're talking about freaking Bitcoin. Well, I appreciate you joining us. Like I said, all of this information, including Paul's contact information, will be available at lawinsider.com/resources. If you want to be a contributor on the Contract Teardown Show, come beat up some contracts as Paul and I did, then just email us. We're at community@lawinsider.com. We look forward to seeing you guys at the next episode. Paul, thank you again. Have a good day.
Thank you very much. Bye-bye.